Good morning, everyone. Happy Monday morning. Welcome back to another edition of Beyond the Soundbite, where we talk about all things U.S. immigration. I am Carol Williams with Williams Immigration, a boutique immigration firm, helping you with your immigration needs. So, I like to dive right in. The first thing I want to talk to you all about is U.S. citizenship applications. USCIS wants to increase those filing fees. And honestly, I feel like it was just yesterday that we had another significant increase on them. But they have a proposal out that is going to increase the filing fees from what is currently $760 to $1,330. So they are looking to significantly increase the filing fees for the citizenship application. It is right now a proposal. It is not final yet. So if you have comments that you would like to submit, they are accepting comments through, I believe, August 24th of this year. But the takeaway is these fees will probably go up. They will probably make this final. So we are looking at an increase from what is currently $760 to $1,330 for new citizenship applications. The next thing I wanted to let you all know about is the Supreme Court gave a decision, was a 6-3 decision regarding temporary protected status for citizens of Haiti and Syria. And the Supreme Court essentially held that USCIS could in fact end TPS for these two countries. It will affect thousands of people. So if you are someone from either Haiti or Syria, you want to continue if you've already started, and you want to absolutely start looking at what other avenues you have to remain in the U.S., if that is what you desire to do. If you are an employer who is currently employing someone who is in TPS status from Haiti or Syria, you want to make sure that you are looking at work authorization cutoff times and making plans around that and having those conversations with your employees. But again, the Supreme Court did rule on that, and they did in fact rule that USCIS could end TPS for Haiti and Syrian nationals. The next thing I want to talk to y'all about is the PERM application. So the PERM application is the first application for some folks who are applying for their green cards through an employer. The PERM application is essentially the application that gets filed with the Department of Labor that says we as a company want to hire a specific individual in a specific role, and that we have not been able to find anybody who is a U.S. citizen who can perform the duties of the job, but we have found someone who is not a U.S. citizen who is qualified and can perform these duties. One of the attestations that is made in a PERM application essentially says that the company can also pay the wage, the offered wage, the required wage to the individual. So we are now seeing where the Department of Labor is asking for evidence that the company can in fact pay that wage. Usually, we see USCIS or the Immigration Service asking for documentation such that we, my colleagues and I, we affirmatively file that documentation at the I-140 stage, which is the second application in the green card application after the Department of Labor does its thing and gives us a certification or an approval. So we are now seeing some requests from Department of Labor to show that the employer can in fact pay the wage. That is a very significant change in the current processing. So if you are currently processing an EB2 or an EB3 application that is PERM based, you may want to keep that in mind, that now Department of Labor has started to ask for ability to pay information. So I wanted to make sure that I got that on your radar screens. I suspect we will probably hear more about that in the coming months. And the last thing I wanted to, it's more of a reminder, back in May of this year, so not that long ago, back in May, USCIS essentially decided that they would no longer allow attorneys to appear via telephone for interviews at local offices. We have now seen an update in their policy that allows for sort of limited circumstances, exemptions to that. We have zero guidance on what that really means. So, I mean, the reality is, I think the ability to appear via telephone is gone. I can't sort of think of what they would consider a reason to let someone appear, let an attorney appear via telephone. So, not saying it's never going to happen. They have allowed sort of this limited exception under limited circumstances, but by and large, it's that our ability to do that as attorneys is gone. So I just wanted to remind you all of that. But that is really all I have for y'all this Monday morning. If you have any questions about your immigration case, your green card case, your perm case, feel free to reach out to us. We are happy to get you scheduled for a consult, happy to have a conversation. Have a wonderful Monday, and